A district judge in Pennsylvania dismissed many of the most serious criminal charges filed against 18 Penn State fraternity brothers. The judge dropped the involuntary manslaughter and aggravated assault against 8 of those brothers. And we are talking about the death of Tim Piazza, a pledge who died in February after undergoing or participating in an alcohol-fueled party. CBS News legal analyst Rikki Klieman joins us now to talk a little bit more about this. Rikki, you've come on several times to talk about this case. So Anthony Piazza is involved in a party where there is a lot of alcohol, and ultimately within that night he falls down the stairs. He is unconscious for several hours before members of this fraternity realize that there's a problem and they take him to the hospital. He dies 2 days later. That's summing up the case. 18 of them have been in front of a judge. And now it looks like 3 of 4, at the end of the day, only 12 of them will face any sort of charges, Rikki.
The decision ultimately by the judge, I think, is a surprise to many, and certainly really devastating to the prosecution, who took an aggressive stance in this case and believed and fought with all their hearts to get charges go to the next level on the issues of involuntary manslaughter and aggravated assault. And those, of course, were charges that carried a 5-year penalty and the aggravated assault a 20-year penalty. Now we're down to reckless endangerment against the remaining defendants. So, as you said, the most serious charges are gone. The reckless endangerment count is a misdemeanor with a 2-year prison sentence. And so the collective sigh of relief, of course, will come to the defense, those who were dismissed and those who are no longer facing a maximum penalty of 20 years in prison. But the Piazza family, which has been really steadfast as well as vocal, must be devastated.
Based on what we know about the case, though, do you feel like involuntary manslaughter and aggravated assault may have been overcharging the defendants in this case?
I don't think it was overcharging if you look at the collective behavior, where it looks like overcharging, which is why these defendants were fortunate enough that they could afford some really terrific criminal defense lawyers who went forward to try to explain to this judge in detail, one of the closing arguments lasting as long as 90 minutes by report, which is usually the length of a closing argument in a major trial as opposed to a preliminary hearing. What the defense did was to say, look, this is not a collective act. This is not simply a joint venture, that you have to look at each of the 18 defendants individually. And what the defense, particularly in the 8 who were charged initially by the grand jury presentment with involuntary manslaughter and aggravated assault, what their lawyers attempted to show, and apparently were quite successful in showing, was what each defendant did. So, for example, if you were a defendant who, I'm using one example, who had the wine station, and there was no video and no evidence that Tim Piazza ever took a sip of wine, well, then you were exonerated at this stage from the involuntary manslaughter and aggravated assault. If you were someone who didn't take a role in the planning, if you were someone who had a beer station and there was no evidence that Tim Piazza stopped and took that beer. In addition, what the defense argued, again, apparently quite successfully, was that there really was not sufficient evidence on the video, they say, to show that it was this gauntlet that the pledges had to run that was the cause of Mr. Piazza's death. But rather, if there was a cause, it may have come later when there was a voluntary social drinking in the basement. And the defense was extremely pointed about that they made a distinction between the gauntlet and the ritual of hazing versus the voluntary social drinking that occurred later on.
Oh, that is very interesting. And I know when we talked earlier, we talked a little bit about some text messages that were also submitted as evidence, in which at least one of the fraternity members said, you know, at the end of the day, I'm accountable. He looked like he was dead, and sort of acknowledging that Timothy Piazza looked like he was in dire need of assistance and nobody came.
Well, I think that the text messages, which I do believe, if the case had gone forward and went all the way to a jury, that the text messages could have really been the death knell for these defendants. Excuse that analogy, that it could have really been the final straw, because the text messages do what we call in the law, they show consciousness of guilt, which can be taken as an element of someone's guilt. But what happened here was the fact that, for example, defendant Brendan Young, who is the president of the fraternity, or Daniel Casey, the defendant who was the pledge master, that when you look at the text messages of various people in the group, what they may have been saying was, as a group, they thought they would be held responsible. But this judge felt that the group activity was not what was going to do them in. It was the individual activity. I do think that it's the text messages that will make people really not understand this decision in the way that this judge has laid it out. And we'll hear, I am sure, from what the prosecution and the defense have to say in various press conferences that they will have. But we'll see what remains in the case ultimately with the reckless endangerment. You may find that this case at that level doesn't even go to trial, but that at some point later on winds up with a plea of guilty because it's a misdemeanor and not looking at a felony.
Oh, that's very interesting, because I was going to ask you, you know, what needs to be proven to get a conviction for reckless endangerment?
Well, when we look at reckless endangerment in the way that the law is written in Pennsylvania, it is pretty close, if not almost identical, to the law that explains involuntary manslaughter. So what you have here is, in essence, a gradation of the same offense. And what it may be much easier for a jury or a judge to convict of reckless endangerment, because, of course, it doesn't sound quite so ominous, and ultimately the penalty isn't either. But reckless endangerment, again, is looking at a risk and not perceiving the risk and the injury that could occur when the risk would have been obvious to a reasonable person. So these defendants, I would say, caught a break from this court, which is not to criticize the court, by the way. I always will respect a judge's decisions, and that I am sure that the opinion is very well reasoned, and when we have time to parse it out, we'll take a look at what this judge felt was insufficient for the bigger charges and what was yet sufficient for reckless endangerment, when someone might say they're really basically the same thing.
So you said that these defendants caught a break, and at least 8 of them had the most severe charges dropped completely. Do you see this going to a civil lawsuit, a civil trial?
Oh, absolutely, civil and criminal. I think you're going to go forward with the criminal case as to reckless endangerment and other remaining charges, including the furnishing of alcohol and the unlawful acts relative to the alcohol, that is going to go forward. And that the defendants, of course, always have a choice if they're going to enter a guilty plea or they're going to go to trial. In the meantime, you clearly have a wrongful death civil suit, which the family not only has a right to bring, but surely will continue to pursue with their very articulate and thoughtful lawyer. So you've really got both of these causes of action, civil and criminal, that will come against these defendants in the future.
All right, Rikki Klieman, CBS News legal analyst. Thanks a lot, Rikki.
Thanks, Emery.